On October 18, 2020, Corinne Durber used her iPad to place a bet on an online gambling site. She was playing Wild Hatter. During the game, 3 jackpot symbols appeared on the reels, triggering the bonus round. The interface instructed her to spin a digital wheel. She clicked. It spun and stopped on the monster jackpot wedge, confirming a win of £1.09 million. But she wasn't paid $1 million. Paddy Power later informed her she only won $20,000. The UI explicitly told her she won a life-changing sum, but the back-end system refused it. The discrepancy was caused by a software mapping error. A human programmer had misaligned the front-end animation with the back-end random number generator. While the server recorded a £20,000 win, the UI triggered the £1 million animation. Paddy Power relied on their click-wrap terms and conditions, specifically Clause B1, which states if the screen and server disagree, our record shall be regarded as definitive. Within the gambling and tech industries, the working assumption is that these server-definitive clauses insulate providers from front-end graphical errors. This forces a very specific legal question. Can a software provider use a buried clause to unilaterally void a win when their own front-end code promised a deterministic experience? Many tech lawyers believed this issue was already settled by the Court of Appeal in Parker versus Camelot. In Parker, a user demanded a £1 million payout because she saw matching numbers on a digital scratch card. However, Camelot's front-end game procedures were highly specific. To win, matching numbers had to be circled in green and flashing. The user's numbers matched, but they remained static. Because they weren't circled or flashing, the UI requirements for a win were never met. Additionally, Camelot's rules explicitly warned that outcomes were predetermined at the point of purchase, before any animations played. The court ruled for Camelot, finding that the animations were legally irrelevant under the terms of that specific contract. Following the verdict, the legal industry broadly assumed that all server-definitive clauses would hold up in court. But Parker was won because the front-end rules and the back-end reality were synchronized. In the Durber case, that synchronization was absent. At the King's Bench Division, Justice Ritchie audited the specific textual promises Paddy Power made to its users. He looked past the general terms and focused on the rules, the specific instructions for the Wild Hatter game. Those rules told the player, spin the jackpot wheel to determine which tier will be won. Determine. The word choice implies that the physical spin on the screen, not a hidden calculation, dictates the prize. This creates a what you see is what you get contractual paradigm. It directly contradicts Clause B1, which claims the hidden server is the sole determinator. These two positions are fundamentally incompatible within a single agreement. A platform cannot promise that a user's visual action dictates the outcome, while simultaneously claiming a hidden record is the only one that matters. To resolve this, the court had to navigate Paddy Power's 45-page document architecture. We have a collision between the specific UI promise in the rules and the general server definitive clause in Part B. The contract includes a conflict resolution filter, the inconsistency clause. It states, in the event of any inconsistency, the rules shall prevail. Because the UI and backend conflicted, the court deleted the backend clause. The rules became the governing law. When specific game rules contradict general conditions, the court holds the provider to the reality they rendered on the screen. The court then asked, even if the terms didn't conflict, were clauses B1 and B2 ever legally incorporated into the contract? This involves the onerous or unusual test, measuring the severity of a term against the design friction required to bring it to a user's attention. As a clause becomes more penal or unusual, the provider must take more deliberate steps to ensure the user sees it. A clause allowing a developer to void a win based on their own undetectable coding error is a significant burden placed on a consumer. Yet, Paddy Power hid these clauses within a 45-page block of text with no bolding and no forced scrolling. This level of notice was insufficient for terms this onerous. Standard click-wrap agreements cannot incorporate high-stakes liability exclusions without disruptive UI signposting. The final barrier for the provider was the Consumer Rights Act 2015. Section 62 prohibits terms that cause a significant imbalance in the parties' rights, contrary to the requirement of good faith. Clause B1 acted as a conclusive evidence clause. It effectively banned the consumer from using their own screen as evidence to challenge the back-end server. Shifting the entire risk of human coding errors onto the consumer violates the CRA's imbalance test, making the terms unenforceable. This ruling ties back-end legal drafting directly to front-end UI define. If your interface promises a deterministic visual experience, your back-end cannot quietly claim otherwise. If the two realities diverge, the court will enforce the one the user actually saw.